Welcome everyone. This is Stephen Avery versus Manitowoc County, Thomas H. Kocourek and Dennis R. Vogel. Plaintiff Stephen Avery and his attorneys, Glenn Fitzgerald Elby by Stephen M. Glenn and Walter F. Kelly. Walter F. Kelly states his complaint as follows. Nature of the case. This is action pursuant to 42 USC 1983 and 1985 to and the Due Process and Equal Protection Clause of the 14th Amendment of the United States Constitution, seeking to redress the wrongful conviction and imprisonment of Stephen A. Avery for felony crimes of sexual assault, attempted murder, false imprisonment he did not commit. Jurisdiction is premised upon 28 USC. The amount in controversy exceeds 1 million and may total as much as 36 million. Stephen Avery is a citizen of Wisconsin, the United States, who resides at 12930 Avery Road in Two Rivers, Wisconsin. Manitowoc County is a body of corporate and political organized under pursuant of the laws of Wisconsin and is addressed as County Clerk, Manitowoc Courthouse, 1010 South 8th Street, Manitowoc, Wisconsin, 54220. At all times relevant to the allegations of complaint, Manitowoc County acted under color of law within the meaning in 1983 pursuant to the official policies, customs, and usages and final authority of the sheriffs and district attorney. Thomas H. Kocourek is a citizen of Wisconsin in the United States who resides at 1601 Shoto Road, Two Rivers, Wisconsin, 54241. At all times relevant to the allegations of the complaint, Kocourek was acting unlawfully under color of law within the meaning and within the scope of employment within the meaning. Kocourek is sued both individually and in his official capacity as sheriff of Manitowoc County, as which county he was the final authoritative decision maker and policy maker with respect to the office of the sheriff in all respects relevant to allegations complaint until January 2001. Dennis R. Vogel is a citizen of Wisconsin in the state of the United States who resides at Bayside Drive, Madison, Wisconsin. At all times relevant to allegations of this complaint, Vogel was acting unlawfully under color of law within the meaning of 42 U.S.C. 1983 and within the scope of his employment within the meaning of. Vogel was sued both individually and as an official capacity as district attorney of Manitowoc County, as which the county he was finally authorized. This is a decision maker and policy maker with respect to the office of district attorney in all respects relevant to allegations complaint until unknown date 1986. In his official capacity, Vogel is sued with respect to the entirety of his function as the district attorney of Manitowoc County in all respects relevant to allegations of his complaint. In his individual capacity, Vogel is sued with respect only to his executive, administrative, and advance and counsel function as the district attorney of Manitowoc County in respect to relevant to allegations of his complaint. On July 29, 1985, approximately 4 p.m., one Penny Bernstein was sexually assaulted, beaten, and threatened with her life, and forcibly held against her will on Lake Michigan Beach in Manitowoc County by Gregory A. Allen. Allen, who had at the time a long and violent record which included sex offenses, had engaged in sexually lewd and lascivious conduct and threatened violence against women on the same beach 2 years previously to his attack on Penny Bernstein. The prosecutor in the case was Vogel. During July 1985, Allen was under active daily surveillance by members of the City of Manitowoc Police Department for suspected sexual assaulted behavior occurring the first half of 1985 up until including July 29, 1985. That was characterized as official police records by the City Department as becoming increasingly very bold. A Manitowoc City Department reported July 14, 1985, stated, "This department has complied several complaints recently concerning prowling, window peeping, indecent exposure, and sexual assault ranging from January 1985 through 7/14/85, in which case Gregory A. Allen has been listed as a suspect. Past record intelligence concerning Gregory Allen reveals he is a dangerous individual with potential for violence." On July 29, 1985, the surveillance of Allen by the Manitowoc Police was discontinued for most of the day because the department personnel were assigned to cover other calls. Allen fit the description of Penny Bernstein's assailant, and Allen's photograph was readily accessible to Manitowoc County Sheriff and the District Attorney. Based upon the facts set forth above, Allen should have been defendant's prime suspect in the sexual assault of Penny Bernstein. At the time Penny Bernstein was attacked, Stephen A. Avery was shopping trip with his wife and children in Green Bay to buy paint for work in his family home. He accounted for the whereabouts through the day on July 29, 1985, and there was corroborating evidence from witnesses and documents to support his account. On July 29, 1985, Stephen Avery was known to be both the sheriff and the district attorney of Manitowoc generally in regard to certain prior offenses, and specifically regarded to a dangerous safety incident involving the wife of a Manitowoc County Sheriff's deputy, occurred on January 1985. The woman was a friend of Manitowoc County Sheriff Judy Dvorak. There was an attitude of hostility within the Manitowoc County Sheriff's Department towards Stephen Avery and the Averys in general. On July 29, 1985, included both Dvorak and Sheriff Kocourek in a simple attitude with the shared district attorney Vogel. As a result of this hostility, neither Dvorak nor Kocourek nor Vogel possessed the objectivity that required the law enforcement investigation of crimes such as those committed against Penny Bernstein by Allen. Instead, each was predisposed against Stephen A. Avery. Penny Bernstein was severely traumatized by Allen's attack and was transported to the Memorial Hospital in Manitowoc, where she was questioned and interviewed during a sexual assault treatment protocol by Dvorak and Kocourek. Although Penny Bernstein's description of her attacker substantially resembled Allen, Dvorak and Kocourek identified Stephen Avery as probable offender, which immediately focused the Manitowoc County crime investigation upon Stephen Avery, intended to permit meaningful investigation of other suspects, including particularly Allen. Kocourek ordered procedures of victim identification, including a composite sketch and a photo selection process that failed to follow professional standards. Presented Stephen A. Avery as a suspect and excluded Allen from the selection process. Penny Bernstein was led to believe that the group of photos presented for her viewing included the main suspect from the sheriff's investigation, considered to be her attacker. Stephen Avery's photo was included. Allen's photo was not. According to the well-known professional victim eyewitness identification principles, once a victim identifies a particular person as a criminal perpetrator, that identification becomes more likely to be repeated on later occasions. Penny Bernstein identified Stephen A. Avery as her assailant, which she examined photos presented to her by Kocourek. A subsequent live lineup was arranged just 3 days later by Kocourek, who had since consulted Vogel and again Allen to exclude from the array. Stephen A. Avery was included, and Penny Bernstein was advised that an arrest had been made by the Sheriff's Department and the arrestee would be in the lineup. Stephen Avery was the only person in a live lineup whose picture had also been shown to Penny Bernstein in the group of photos provided by her by the sheriff. Although Kocourek had discussed the investigation, conferred with Vogel less than 8 hours after the arrest of Stephen Avery at approximately midnight on July 29, 1985. Although Vogel had prosecuted Allen 2 years previously for an assault sex crime on the same beach, neither Kocourek nor Vogel initiated or pursued investigatory efforts and considered Allen as a suspect. Kocourek and Vogel cooperated in planning and execution of the live lineup. Kocourek and Vogel knew in July 1985 about Allen's 1983 conviction for lewd and lascivious assaultive behavior on the same beach. A report of that incident was contained in the sheriff's file investigation attack upon Penny Bernstein and was signed by Vogel. Moreover, the Sheriff's Department knew as of December 15, 1983, both that Allen would be exposed himself and masturbating in front of women and children, and that he had a history of sexually violent behavior, including the fact that he was a chief suspect in the murder of a 15-year-old girl in North Carolina in June 1975. Shortly after the arrest of Stephen Avery, the City of Manitowoc Police Department Detective Thomas Bergner approached Kocourek, attempted to discuss Allen's history, his department's current concerns about Allen as a prime suspect in an attack on Penny Bernstein, and Bergner's impression that Kocourek knew about Allen and Allen's history. Kocourek told Bergner that Allen had ruled out the suspect, statement incredibly that inconsistent that Kocourk's repeated denials following the event stated, therefore, excuse me, and they acknowledged Allen's August 1985 thereafter until September 10th, 2003. Pursuant to its official policy, custom and usage in 1985, Kocourek made no memorandum of other writing of Penny Bernstein's investigatory file that recorded the contents of the information provided by Bergner. Further, pursuant to the official policy, custom usage in 1985, Kocourek made no request indirectly of the City of Manitowoc Police Department, whether before or after his conversation with Bergner, for the information concerning Allen. Bergner believed that Allen should have been investigated as a prime suspect as assault on Penny Bernstein, and because of the suspect and other sexual assaults at the same time, including an attempted sexual assault on July 14, 1985 in Manitowoc. Trouble by Kocourek disinterest in pursuing Allen as a suspect, particularly in the view of them and current alarm of City of Manitowoc's officers. Allen was declaring his sexual assaultive proclivity, and Bergner contacted Penny Bernstein. Penny Bernstein herself, concerned at the time, communicated to the sheriff that she was receiving harassing phone calls of a sexual nature shortly after she entered her home, causing her to feel that she was being watched. Penny Bernstein contacted Kocourek and told Bergner's information. She was alarmed her assailant might still be at large and stalking her, behavior that was consistent with Allen's history. Kocourek did not tell Penny Bernstein of Allen's existence, history, or surveillance. He did not tell Bergner's alarm of the city department's pointed concerns about Allen. He did not tell her ruling out Allen as a suspect. Instead, he told her to disregard the matter and that he would take care of it, as the case was with Manitowoc County's jurisdiction, not the city's. Pursuant to the same official policy, custom usage in 1985, as alleged in, hereof, Kocourek made a memorandum of other writing of Penny Bernstein's investigatory file, recording the contents and information provided to him by Penny Bernstein following her contact with Bergner. The captain of detectives and other members of the Sheriff's Department in 1985 expressed their beliefs to the sheriff that the investigation focused too quickly and specifically upon Stephen Avery, and inclusive of other suspects, including the man known for committing sex crimes like that one upon Penny Bernstein, who matched Penny Bernstein's description, who was seen in the area when Penny Bernstein's sexual assault took place at the time that it occurred. Kocourek allowed his investigatory personnel to no further investigatory pursuit of suspects other than Avery and no pursuit of Allen. Pursuant to the same official policy, custom usage in 1985 is alleged in, hereof Kocourek made memorandum or other writing for Penny Bernstein's investigatory file that recorded the contents, the information, objections providing to him to the captain detectives other with the Sheriff's Department in 1985. Upon information that believed Kocourek told Vogel about Bergner's information concerning Allen, Penny Bernstein's ensuing phone call and further information objections of the investigatory personnel. Upon information and belief, pursuant to the official policy, custom and usage in 1985, Vogel made no memorandum or other writing in the Penny Bernstein prosecutorial and investigatory file in the district attorney's office concerning the information provided by him by Kocourek or Bergner. Penny Bernstein's current information objections of Kocourek's investigatory personnel. Further, pursuant to his official policy, custom and usage in 1985, Vogel made no request to the City of Manitowoc Police Department for information concerning Allen. At the time of the investigation and the prosecution of the attack upon Penny Bernstein, Vogel knew that members of his office staff believed in objective, reasonable grounds that Stephen Avery was not the person who attacked Penny Bernstein, and that Allen was the person who attacked Penny Bernstein. Upon the information and belief, Vogel discussed the views of some members of his staff in Kocourek. Pursuant to his official policy, custom and usage in 1985, Vogel made no memorandum of other writings in Penny Bernstein prosecutorial and investigatory file in the district attorney's office. Either the views his staff members set forth in. Hereof is a discussion of the views with Kocourek. Had Kocourek and Vogel reviewed the police reports from Manitowoc Police Department on July 29, 1985, the following information would have been specified, adding to the likelihood of Allen as the prime suspect upon Penny Bernstein. Allen had convicted of aggravated offense as a juvenile. According to the police report from the Trouver Police Department on August 2, 1983, Allen came up over some sand dunes on the same beach on which Penny Bernstein was assaulted, only some distance south of that point, and began walking behind a woman. He then pulled his shorts halfway down and began masturbating. He then lunged at her, but the woman was able to escape. Following the incident, Allen contacted the victim twice at her home and asked her to drop charges. The victim had moved to Green Bay for school and did not know how Allen knew this or how he knew her phone number. Allen also contacted the victim's mother 5 days after the offense and asked to talk to Sue, which was the victim's name. Allen had been convicted on February 2nd, 1984 for the disorderly conduct in the city of Two Rivers. On July 13th, 1984, Allen was a suspect in a prowler case in which he attempted to gain entry into a woman's residence in Manitowoc after following her 16-year-old daughter and her daughter's friend to that residence. Allen was suspected of prowling on January 24th, 1985, and February 2nd, 1985 in Manitowoc, involving walking into people's yards and up to their garages and homes. On January 26, 1985, Allen was a suspect in the investigation, which a woman told Manitowoc police that at 6:30 a.m. she saw a male subject wearing a ski mask between her yard and neighbor's yards, and the suspect had taken a brick and moved it to the other side of the yard fence in order to stand on it and see in the neighbor's windows. The neighbor had a high school-aged daughter. On June 26, 1985, just 1 month prior to Penny Bernstein's assault, Allen was a suspect of going into a woman's front door at 2:30 a.m. and exposing himself, wearing a red t-shirt wrapped around his head. The victim could see the man's eyes, nose, and mouth. She found out later her kitchen window was removed. Also, a bedroom window on the north side of her house had 12 Phillips screwdrivers removed from it. Allen was stopped on a motorcycle a short distance away, wearing a red t-shirt. Allen matched the description, except he had a mustache. He was arrested for traffic violation for being a suspect in a vehicle entry the same day in which his vehicle owner had 2 daughters. Allen had 2 Phillips screwdrivers in his possession. Despite the evidence, Allen was not charged for this incident. On July 14, 1985, 2 weeks prior to Penny Bernstein's assault, Allen was the suspect of breaking into the man's home at 3:28 a.m., attempting to assault his daughter. The daughter awoke to find a man standing there, sitting on her thighs and fondling her breast. He then placed a knife to the girl's throat, saying she was going to take our clothes off and would kill her. He was nude and had a bathing suit wrapped around his head, covering his entire face and hair. The victim stated that she had a period and did not hurt her. She brought her hand onto his penis and made her masturbate him until he ejaculated on her nightgown. He asked where her sister was, and she said her sister was not home. He then ordered her to accompany him to the back door, where he had her let him out. As he was leaving, he told her not to tell anyone or he would kill her. A neighbor stated he saw a man park his motorcycle near the victim's house approximately 2:30 a.m. and walk toward the victim's house. Allen had a motorcycle. Another neighbor stated approximately at 2:42 a.m. she observed a man carrying a picnic bench between her house and the victim's house. The suspect had gained access to the house through the window. Another neighbor had seen a man duck into the bushes of the victim's house 1 month prior to July 14th incident at approximately 8:30 p.m. and then saw a motorcycle parked in front of an elderly couple's house nearby. All this information concerning Allen, alleged, and the 37-year-old material exculpatory evidence that was timely requested of Vogel and Kocourek by attorneys representing Stephen Avery was not provided to them. This was severely prejudicial, and the information would have prevented the prosecution or conviction or imprisonment of Stephen Avery between 1985 and 2003. All the acts and omissions of forth committed by Kocourek and Vogel were intentional or reckless disregard of the rights of Stephen Avery. The differential treatment of Stephen Avery and Allen as possible suspects in Penny Bernstein without rational basis was premised upon personal hostility towards Stephen Avery. The policies, customs, usages alleged in were those of Manitowoc County acting through the highest ranking authoritative law enforcement decision makers, its sheriff and district attorney, and were causes of failures to exploitate Stephen Avery as alleged in. After his conviction, Stephen Avery constantly maintained his innocence and sought by appeal post-conviction remedies to set aside the convictions. His attorneys continued to seek to pursue exploratory evidence, notwithstanding their affirmative obligation to provide information concerning Allen alleged in. And hereof, even after Stephen Avery's conviction, Kocourek and Vogel continued to fail to provide such information to Stephen Avery or his attorneys. In March 1986, Vogel prosecuted and convicted Allen for sex offenses, which again brought to Vogel's attention exploratory information concerning Allen that should have been provided to Stephen Avery and his attorneys. Due to his efforts, Wisconsin Innocence Project, conclusive DNA evidence, Stephen Avery exonerated and released the final court judgment in September 2003. The same DNA evidence constitutionally implicated Allen, who had committed further violent sex crimes between 1986 and 1995, an assault, beating, and attempted murder of Penny Bernstein. First cause of action. The actions and missions of defendants of Kocourek and Vogel in Manitowoc County in targeting Stephen Avery, failing to investigate Allen as alleged, hereof deprived Stephen Avery of a due process of law. Comprehensively shocked and concerned in violation of due process clause in the Fourth Amendment United States Constitution. Second cause of action. The actions and missions of defendants Kocourek and Vogel in Manitowoc County is alleged, hereof in the differential treatment of Stephen Avery and Allen as suspects in the Penny Bernstein assault case. Upon grounds of personal hostility and irrationally deprive Stephen Avery of equal protection in the laws provided in the 14th Amendment to the United States Constitution. Third cause of action. The actions and omissions of defendants Kocourek and Vogel in Manitowoc County as alleged in, hereof failing to record or provide to the defense counsel for Stephen Avery material acceptable evidence concerning Allen that was timely and lawfully requested pursuant to Stephen Avery and denied him the process law. Now, you guys see a pattern here? It's the same thing that happened in 2005, happened in 1985. Only difference is Penny Bernstein didn't die. Post-conviction continued failure to defendants Kocourek and Vogel in Manitowoc County to become forward material exploded evidence known to them concerning Allen. I mean, who's to say that they may know, all as well know what happened to her? They just had a better idea of what they needed to do because they're trying to save their asses. This shit just infuriates me. Post-conviction continued following the defendants Kocourek and Vogel in Manitowoc County to forward the material explosive evidence known to them concerning Allen throughout the 18 years of Stephen Avery's imprisonment constitutes a violation of due process and equal protection clauses of the 14th Amendment United States Constitution and continuing hindrance. An obstruction of due course of justice, violation of obstruction clause, damages. As a result of the actions and omissions of Kocourek, Vogel, and Manitowoc County alleged in, Stephen Avery suffered a loss of his liberty and dignity for 18 years. He had been treated by society as the worst kind of criminal for 18 years. He suffered the destruction of ordinary civilian opportunities to work and earn a living and all the economic social benefits accompany an earned living for more than 18 years. He has become permanently, economically, and socially disabled. Has suffered a loss of personal autonomy in his most intimate personal and family relations. He has been deprived of countless experiences of life that accompanied free citizenship in Wisconsin and the United States. These losses exceed $1 million and may total as much as $18 million. The actions and omissions of the defendants Kocourek Vogel alleged in hereof an intentional and a reckless disregard of rights of Stephen Avery is so outrageous as to warrant the imposition of punitive damages upon each of that they may exceed $1 million and could total up to $18 million. Immediately, wherefore, plaintiff demands judgment against defendants Manitowoc County, Kocourek, and Vogel for compensatory damage, jointly and severally, in amounts exceeding $1 million and totaling up to $18 million for punitive damages against defendants Kocourek and Vogel individually in amounts exceeding $1 million and for each defendant totaling cumulatively to $18 million. So that's why the $36 million came in, because he was suing them both for the same amount. And then indemnification of the benefit of Stephen Avery over against Manitowoc County of all damages assessed against defendants Kocourek Vogel pursuant of State Statute 8946. All costs and reasonable attorney's fees pursuant and for such of the further relief applicable to legal county may be deemed proper and just plaintiff hereby demands trial by jury dated on Milwaukee, Wisconsin, this day, the 12th of October 2004. This is the first document submitted in Stephen's lawsuit against Vogel and Kocourek. I will be going over all of them because I have access to everything now. So, yeah. Civil cover sheet. Plaintiff Stephen Avery, defendants Manitowoc, Kocourek, Vogel, attorneys, blah 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 blah. Yeah, but see y'all in the next one.